you both for your arguments. We now proceed to the fourth and final case on the docket for today. Campbell versus the state and Campbell versus Jones.
May it please the court. Good morning. My name is Julie Morley, and I, along with co-counsel, represent the appellant, Mr. William Campbell. I'd like to focus this morning on argument one of our initial brief. In argument one, Mr. Campbell alleges that he was provided prejudicial, ineffective assistance of counsel for trial attorney's failure to suppress the 5 incriminating statements he made after his arrest but prior to his contact with the attorneys. The attorneys here failed to take the most basic step to protect Mr. Campbell's right against self-incrimination.
But wouldn't you have to, for that, hold that although maybe there are some places where that's done, that the public defender's office would have to be checking on everyone's arrested and before there's even an arraignment actually seek to represent that defendant?
So that encompasses argument 2 of our motion about the rapid response of the lack of the...
So what was,
argument 1 has to deal with the voluntariness of the statements themselves.
Okay, based on him being in, sorry.
Correct,
okay.
And their failure not to file a motion to suppress, but we can address the second part later. In this case, it's undisputed that the trial attorneys never hired a pharmacologist and never learned that Mr. Campbell was consuming high level of opiates, that he was opiate naive, so he had no tolerance for these opiates, and he was legally impaired during each of these 5 interviews. To give some context to when the interviews were given, several hours after the homicide occurred, Mr. Campbell wasn't involved. Yes, sir.
The trial counsel testified as to a reason for strategically deciding that those statements should come in based upon the remorse that your client expressed toward killing his father. And I think that the trial court found that. So why isn't there competent and substantial evidence to support a trial court finding of a strategic reason for not seeking to suppress the hospital statement?
So we believe the trial strategy was flawed for 2 reasons. The first is that a reasonable strategy needs to be based on informed judgment of all the facts, and it was undisputed, and the trial attorneys testified that they never hired a pharmacologist to review these records, and they never learned about Mr. Campbell's specific opiate naivety that would make him much more vulnerable to these drugs that he was on. But secondly...
Didn't counsel testify that this really was a penalty phase case? There was no question that he could reasonably raise with respect to guilt, and therefore the statements where the jury heard the statements of remorse would be helpful. I don't see why that has anything. If you decide that, why would you even bother pursuing a pharmacologist?
So trial counsel argued that their strategy in the guilt phase was to attack the premeditation element. And part of what they saw in Mr. Campbell's statements was the remorse would be helpful with that. But they did testify that the 5th statement, which happened several days after the hospital at the local county jail, while he was still under the influence of these narcotics, was problematic because it was very different from the first 4 statements. It shows a heightened premeditation, and the only way to really counter that 5th statement was by putting Mr. Campbell on the stand to explain that statement away. The remorse angle and the strategy that the trial counsel wanted in this case could have been accomplished without these statements. There was a state witness, Margaret Driggers, who the state used to bring in text messages that were exchanged between Mr. Campbell and herself after the homicide occurred but prior to his arrest, and then letters that Mr. Campbell subsequently wrote to her while he was incarcerated at the county jail. In these letters, the remorse element that they were trying to demonstrate is shown. There is a confession to the murder itself, but there's no intent described in it. There's no plan, there's no premeditation described. There is no doubt that absent these statements, premeditation would have been very difficult for the state to prove in the guilt phase. And the prejudice here also applies to the penalty phase. And Even though Mr. Campbell is receiving a new penalty phase because of...
But was that the final, was that the statement when he was out of the hospital that
Correct.
you're talking about? And so is that statement different? I mean, he's been released from the hospital. He's not at least on the same level of medication, is he?
He's on different medication at this point. Our
Exactly. And
post-conviction pharmacologist explained that he was
Doesn't
on...
that make a difference as to whether or not those particular statements would have even been suppressed?
Well, they never even investigated whether they could suppress them.
I understand your argument about the non-investigation, but I'm talking about on the merits of it. It seems to me that given the circumstances of how that statement was given, that it seems very likely, certainly less likelihood that that statement would have been suppressed.
The circumstances of the fifth statement, he was released from the ICU in the hospital to the medical ward of the county jail. He was still in a stretcher. He was still taking high-dose oxycodone and continuous-release OxyContin, and he was still in medical and mental distress. He was still suicidal at the time. So under the totality of circumstances, and the expert, as testified in post-conviction, that statement still was, he was still legally impaired at that point as well.
This is Dr. O'Donnell?
Yes, sir.
You're talking about? Didn't he also testify on cross-examination that he, upon listening to the tapes, that he sounded coherent, was able to answer all the questions and made sense?
He did, and he also testified that impairment does not necessarily mean that one can't communicate. One wouldn't have to be in a rage or hysterics, that part of the impairment from these specific narcotics that Mr. Campbell was on affects the ability to be able to consider the consequences of the words that the person's speaking. So that would go in, and he described that he runs these institutional review boards, and that a person like Mr. Campbell, under the same mental distress, physical distress, and the level of narcotics he was receiving during this time, and being opiate naive, he would never allow in a clinical or a research setting this type of person to give consent. What's important, and even though Mr. Campbell is getting a new penalty phase due to the Hurst case by the trial court here, the prejudice is still going to be extending to a new penalty phase when he goes back to the trial court. And in this case, there were 4 aggravators that the trial judge found, 3 of which were supported by Mr. Campbell's statements. The CCP aggravator was exclusively found by Mr. Campbell's statements.
Now, you think you're precluded a new penalty phase for making some of the arguments that although the aggravators were found and his guilt is there, that those statements were made when he was under medication? Do you think you're precluded from putting that testimony on?
I'm not sure. I'm not sure, Your Honor.
I don't know why you would be precluded.
I'm sure the attorneys can still re-argue those issues again.
I mean, because it goes to the strength of the aggravators.
Right. I agree, especially the CCP aggravator, which was exclusively found by Mr. Campbell's statements alone and upheld by this court in their direct appeal opinion. Waivers of the constitutional rights must be voluntary, and the person needs awareness of all the relevant circumstances and likely consequences. Dr. O'Donnell on post-conviction testified that the narcotics that Mr. Campbell was on during each of these 5 interrogations would infect his deliberation, would affect decision-making ability, his impaired judgment, executive functioning, issues with impulsivity, the ability to think clearly and consider consequences. There was a general practice sports medicine doctor that the trial attorneys consulted with to just review these medical records generally. The trial attorneys did say in post-conviction, though, that if they were going the strategy of trying to suppress the statements, that they would have absolutely never used that as an expert, and they would have focused on an expert in pharmacology or toxicology. If there's no other questions at this point, I'll pass and I'll save the remainder for rebuttal. Thank you.
Good morning. May it please the court. I'm Patrick Bobek with the Attorney General's Office, and I represent the state in this case. I'd like to start by addressing the issue of trial counsel's intentional strategic decision not to attempt to suppress Mr. Campbell's confessions. Before we ever got into his confessions, this was a case where acquittal was never a reasonable or realistic option. He had already confessed to the murder before he was ever in the car accident to his ex-girlfriend, Margaret Jiggers, via text message. Those text messages were introduced at court. When the body was found, there was a shirt on top of it and a picture of the defendant's sister and the victim's daughter on his face. And then that was covered up too, which led to the police.
Could you keep your voice up, please? I'm having some heart
Oh, sorry.
difficulty when you get to the end of your sentence.
Yeah, sorry. And so that led the police to believe that maybe it was a relative or somebody who was involved, so they immediately went to Mr. Campbell as the main suspect. They found out that he'd been using his father's credit cards multiple times after the murder would have occurred. He's on tape talking to the credit card company, trying to get it reactivated after it stopped working. There were 35 $2 bills that were stolen from the victim's house that were exchanged for larger bills at a gas station, which were recovered. One of his friends testified that he was with them when all that happened. And so we already had a confession. We already had him using...
When you say you already had a confession, is this a statement he made to the girlfriend?
Yes, before the crash or hospital or any of that ever happened, he sent her text messages admitting to the murder. He even said he used an axe. She said she didn't believe him. He said, you can call the cops, which she did. And they told her to keep in contact with them and let them know if he kept contacting her. So before he's ever on any medication, we have a confession. And then we have him using the credit card. And
Was there any forensic evidence there? I mean, was there any fingerprint evidence? But this was his father's house. I guess
Right.
He had access to it.
Right, he actually lived there with his father. And the evidence was that it was basically a hoarder house when he got there, and it had only been kind of cleaned up. The only forensic evidence they had was the victim's DNA on the hatchet that was used.
Just the victim's DNA.
Right. They didn't look for his DNA, and they didn't find any. They would have found his fingerprints all over the house, but I don't know if they looked for them, but there was no testimony about his fingerprints on the hatchet. So because this was a case where he was always going to be convicted of something, their strategy was to try to attack the premeditation element and hopefully get a second-degree murder conviction or try to sway some jurors over to their side for the penalty phase, which I think they were successful in since this was an 8-4 death recommendation.
Just one quick question to the facts, going back. While he was being sought by the police, did he not text his girlfriend and tell her that he had killed his father with an axe?
Yes, he did.
Okay.
Yeah, and again, that was before there's any question about voluntariness due to medication.
But if their focus was on the penalty phase or having it reduced from a first-degree murder, it seems to me that the statement post-hospital and in the jail is a very damaging statement to that kind of strategy. So why wouldn't they have at least tried to suppress that statement?
So I agree that one's definitely the most damaging, but I would point out that he was on different medication at the time, and it was 4 days after the crash. So he was no longer on the morphine or Diprivan drip. He was on oxycodone and Oxycontin, and the expert...
Just on that, isn't there testimony oxycodone is actually worse than morphine?
I think I think the expert at the evidence hearing...
Or whatever.
Right. I think he was trying to downplay the differences. He said that oxycodone and Oxycontin don't reach as high levels as morphine and don't reach them as quickly, but he was still saying he would have been just as impaired. I don't know how you can say he's just as impaired if he's not reaching these high levels of intoxication.
What did the judge, after hearing this testimony, did he say he would have suppressed the statements?
No. In fact, he basically summarily rejected all of it and said that it was not supported by the record. And so this was the same judge who sat in the trial and heard all the testimony, and the same judge who did the evidentiary hearing. So had they filed this motion to suppress, it never would have been granted. So there's no prejudice. There's no...
It just would be, okay, so on the issue, though, as to whether it might have altered the jury's determination on aggravators, do you agree that you're not precluded from putting that kind of evidence on in a penalty phase if they...
I think if they think it's relevant evidence to put
Or
on it,
mitigate against CCP if there's
Right.
something there.
I think it's just as relevant in the penalty phase as it was at the evidentiary hearing.
And so the trial judge heard all the evidence from the pharmacologist and still, at page 13 of the order, found that the statements made were voluntary.
Yes, he said that the idea that they were involuntary was rebutted by the record.
And then he goes on and said the statements were voluntarily made and.
Right, and he said it was a strategic decision not to challenge them. So then I did want to get into this rapid response argument that was made in the brief. I just want to lay out the timeline of events. So the murder occurred on August 10th. The arrest crash was August 11th. He gave 2 statements on August 12th, 2 on August 13th, and 1 on August 16th. And then August 17th was the first time the public defender's office was ever appointed to represent him. And before that time, before August 17th, they had no duty to him. So I don't see how they can be deficient in the representation when they didn't represent him. It's sort of a
The
contract.
17th is after the final statement that we're talking about.
Right, he never gave any more statements to police after August 16th, and they weren't appointed until August 17th.
And at that point, he didn't ask for an attorney. I mean, that would be a whole different issue.
So in his first statement, as they were getting into asking about the murder, he said, I don't want to answer any questions without a lawyer. And at that point, they ceased questioning. A few minutes later, he changed his mind and said he wanted to go back on record.
This is the first statement in the hospital.
Yes.
Okay.
And so, he was coherent enough to understand that he could ask for a lawyer. He was coherent enough to understand his rights and invoke them and then waive them. In fact, he was read Miranda before every single statement he gave on tape. So this is not a case where, one of the cases cited by defense was Mincy v. Arizona. And in that case, the person came to the hospital depressed to the point of a coma. They were in the hospital for almost a month. They couldn't give verbal answers. They were only able to give written answers that were incoherent and unintelligible, that showed they weren't thinking clearly, and those answers were thrown out.
Did they have him as, he murdered his father?
Yes.
And this really goes to, when they decided to actually arrest him. What was it they needed from him to effectuate the arrest? Didn't they already have the evidence from, what other evidence did they have?
Right. I don't think they needed a confession, but everybody loves a confession, and being
Yeah,
able to play a
especially a
confession.
confession without an attorney.
Well, yeah. I was thinking for a jury. If going to a jury and having a confession is always better than
I know,
not.
but was he in ICU at the time?
I can't remember his ICU. He was definitely, he had to be extubated for the conversation.
He had to be what?
Extubated. He'd been intubated, and they had to extubate him. I believe he was in the ICU. If I had to go back and read the transcripts of the conversations, but if you listen to the tapes, because I did, and you read the transcripts, he was in pain. He's post-op, but this is not somebody who couldn't understand what was happening.
Right, but the main thing is that we're hearing here that the attorney who was in charge of deciding what to do with this thought that these statements as a whole were actually beneficial to mitigate against extreme premeditation and again, this issue of whether he was under mental or emotional duress when he axed his father.
Right. Given the other evidence in the case, the extreme remorse he expresses in these statements and the guilt he feels, they felt outweighed the confession. Because again, this is not a case that even needed a confession. So really the damage caused by the confession was way outweighed by the remorse he showed for a jury. If there are other questions, I would just rely on my brief. Thank you.
Thank you. May it please the court, just a few points to follow up the state's comments. The first 4 statements that were given, the circumstances around those, Mr. Campbell, after the car accident where he drove 100 miles an hour without his seatbelt on into a parked cruiser, attempting to commit suicide, he was airlifted from that scene. He was brought to a trauma center. He was in the ICU unit for the first 4 statements that were provided to law enforcement officers. The first 2 statements happened hours after he had emergency surgery, and only seconds after he had his breathing tube removed. That's when the law enforcement officers took the first 2 statements. The next day, they came back and took 2 more statements. He was still in the ICU, still recovering post-surgery, still on the same level of narcotics that he was on the day prior. In this case, the judge's sentencing order, not sentencing order, the judge's order following the post-conviction evidentiary hearing, he found the statements to be voluntary, but in his order, he only focuses on the first and second statements. He gives no findings as to the voluntariness of statements 3, 4, or 5. So we would argue that, 1, the order is incomplete, and the reason he only focuses on 1 and 2 is about Mr. Campbell asking for counsel in between those 2 statements. That is not recorded. That was only testified to by the law enforcement officer who took the statements. The Miranda waivers, which were reread to him and read to him in the beginning, were also not recorded. So that is just coming from the law enforcement officer's memory. There was no other physical evidence, forensic evidence, tying Mr. Campbell to the crime. There, as Justice Pariente was stating prior, there was no DNA, there were no fingerprints, because he did live in the trailer with the victim in this case. The statements he made to Margaret Driggers would have been an admission of his guilt, so this wasn't an issue regarding guilt. The issue is about intent. And the statements here, the state uses repeatedly throughout the guilt phase trial, in opening, in closing, in direct examinations of witnesses, to support the reflection element. How long it took for Mr. Campbell to walk outside to grab a weapon and come back in. How long he was standing behind the victim. How many blows were administered. How much time was between the blows. All of that, which they use to support the premeditation reflection element, comes from Mr. Campbell's statements solely. The prejudice in this case is paramount, and there's no doubt that absent the statements, the premeditation element would have been much more difficult to determine. The trial counsel's strategy of trying to show remorse could have been done in alternative means. There seems to be no logical reason of why a trial attorney wouldn't just attempt to try to suppress damaging statements given by their clients, and then if a bad ruling comes, make a new strategic decision of how to proceed from there. We would argue that we would ask you to reverse the trial court's ruling in this case and grant Mr. Campbell a new guilt phase trial. Thank you.
We thank you both for your arguments. This session of the court is now concluded.
All rise.